My name is Richard Suarez, and I'm a neutral at JAMS, and I do arbitrations, I do mediations, I do neutral evaluations, and I do mock appellate arguments. I was a litigation attorney and an appellate attorney for a number of years in both state and federal court. I was appointed by the governor of the state of Florida to fill a vacancy at the county court level, trial court, and 2 years later to fill a vacancy at the 3rd District Court of Appeal, where I was for about 14 years, 2 of which I was chief judge. I think I would describe my mediation style as laid back. I like everybody to feel very comfortable. I like the parties in particular to know that I'm interested in their case, I understand their case, and I want to try and help them get it resolved. I found humor to be very, very important, particularly on the bench. But in ADR, you have to know when to use it and how to use it. It can be a great icebreaker, puts everybody at ease, and then you get back to the matter at hand. The most important part of an arbitration in preparing for it is like being a judge. And what I do in my arbitrations is, for a pre-hearing conference, I require the attorneys to submit to me paragraphs and papers concerning their positions of their case, the facts of their case, the law, the issues, and what they hope the outcome should be. The practice areas that interest me most are insurance law, all aspects of insurance law, employment, contracts, commercial litigation, and appellate, mediation, and appellate law. My background lends itself to neutral evaluation because for almost all of my career, not only was I a litigator, I also did my own appeals. I did other attorneys' appeals in the firm. And then after being a trial judge, I became an appellate judge for 14, almost 16 years. And so I understand what it takes when you're in court and what it takes when you're doing your appeal and how it needs to be addressed. People don't realize how obtrusive litigation and appeals is to their normal everyday life until they get involved in it. It becomes very personal. And you have to talk to the parties and then help them to understand that what you're doing in a mediation in particular, or an arbitration, is arriving at a business decision to get it behind them.